Look at a typical local checkout counter today. Millions of everyday transactions, like scanning a simple UPI QR code, leave a digital footprint. India has transitioned into a digital-first economy, where personal data is generated at an astonishing speed. That massive volume of data creates massive vulnerability. We see Aadhaar leaks, databases exposed online, and sensitive records held for ransom. In an unregulated landscape, citizens are continuously exposed without any legal recourse. That exposure forced a legal reckoning. In 2017, the Supreme Court of India formally recognized privacy as a fundamental constitutional right for every citizen. Because privacy is now a fundamental right, the way a company handles its digital records has moved beyond a technical concern. Mishandling this information has become a direct legal liability for any organization in the Indian market. The legislative answer arrived with the Digital Personal Data Protection Act of 2023. It is India's first comprehensive privacy law governing exactly how organizations collect and store digital personal data. Rather than relying on a patchwork of outdated IT rules, India developed a framework designed for its specific digital needs, including new features like consent managers to give citizens a single portal to manage their permissions. Data privacy is no longer an abstract ethical concept. It is an enforceable, daily operational mandate for any entity operating in or targeting India. To understand the law, we look at this relationship model. The data principal is the individual citizen. The data fiduciary is the organization deciding how that data is used, and the data processor is the third party handling it for them. In practice, this means when a school collects student data, the school acts as the fiduciary. If they use an external software platform to track attendance, that platform acts as the processor. The law gives the data principal sweeping new rights. Individuals can demand to access their stored data, correct mistakes, erase records entirely, and even nominate someone to act on their behalf. Citizens maintain total ownership and legal recourse over their digital identity long after they click Submit on a form. This graphic shows the new standard for consent. Pre-ticked checkboxes and bundled terms of service are illegal under DPDP. Consent requires a plain language list where users make free, specific, and unambiguous choices. Once you acquire lawful consent, the compliance burden kicks in. Organizations must implement reasonable security safeguards and delete the data the moment it fulfills its original stated purpose. For large-scale or high-risk handlers, the government assigns a significant data fiduciary label. This classification demands extra obligations, including periodic independent audits and appointing an India-based data protection officer. The era of collecting data just in case it becomes useful is over. Under DPDP, every single piece of data requires a defined purpose and an expiration date. A basic firewall will not satisfy the DPDP Act. Organizations must track their data continuously with a record of processing activities while enforcing strict internal access controls and encryption. Handling sensitive information like biometrics or children's data multiplies the compliance requirement. EdTech apps and schools face absolute bans on behavioral tracking and must secure verifiable parental consent before processing any student data. Massive breaches rarely start with cinematic hacking. As the simulation illustrates, they originate from weak vendor access, misconfigured cloud servers, or an insider misusing credentials, instantly spreading through the system. When a breach happens, the clock starts. Organizations have exactly 72 hours to assess the damage and notify both the affected users and the Data Protection Board of India. Silence is illegal. Failing to report a data leak is prosecuted as an entirely separate, severe violation of the Act. Failing to protect personal data triggers penalties up to 250 crore rupees. Violating children's data rules carries a 200 crore penalty. Organizations avoid these using a 90-day roadmap. Discover and map dates as a core legal requirement. The organization remains responsible for the data even when a third-party vendor is processing it. Comprehensive compliance builds customer trust, and in a digital economy, that trust functions as an organization's greatest competitive moat.